His dentist is called James. James is a young dentist. And because he's young, he doesn't have a lot of experience. He has to inject Rick with an injection. The injection goes in the wrong place. He injects one of the nerves in Rick's face. As a result, Rick suffers from permanent facial damage. His face doesn't look normal anymore, it's like this. Why? Because one of the nerves have been damaged. Does he have a case against his dentist, James, or not? This is point one. Yes is easy, even I can say yes. You need the evidence and the background and the case law and the explanations, yeah? Number two, the same dentist this time treats somebody else, another patient, a woman called Carol. This time, the injection goes well. He doesn't hit a nerve. But the problem is, when Carol is walking through the waiting room, she trips over some children's toys. And as she trips over, she gets a bruise on her shoulders. She comes back to the surgery the following week for a checkup, and she sees that on the same surgery floor, this time, instead of children's toys, there are lots and lots of magazines. Does she have a case against the dentist, James, for negligence? Number three. By the way, the answer to number two is also yes. Number three. James treats a third person, Nassim, who comes to the surgery because he has a loose tooth. Because Nassim's brother Imran smacked Nassim in the face when they had an argument. James fixes the loose tooth, but he says for 3 months you have to be very careful. For 3 months we don't want this tooth to move or be damaged. So it needs to heal. Don't go around boxing, don't go around hitting and punching other people in the face to get punched in the face yourself, and don't go around doing crazy sports like rugby. Nassim doesn't listen to the advice, he goes and plays rugby, and the tooth falls out. Does he have a case against the rugby player from the other team who did the dangerous tackle which resulted in his tooth falling out? Yeah? So, 3 cases, give your advice. And the kind of advice you give has to be in more than 1,000 words or whatever it is that is asked you. So, not short, yes, no answer.
So what do you think? Does
Of course not.
Sorry?
What do you think? Does Nassim have a claim against
Does Nassim have a claim? Well, let's start with Rick first, one by one.
Yes.
Yes? So, for the moment, what I have to do is this,
It's not strong.
because, why is it not strong?
No, the claim and again, Nassim, yeah.
No, we're talking about the first one, Rick.
Sorry?
Medical negligence.
Are you sure?
Yeah.
Why?
Because he'll be treated like an expert, whether or not he has whether or not he's experienced.
Whether or not he's experienced,
He's qualified.
the law says you have to have
Duty of care.
not just duty of care. No. Nettleship versus Western is
Oh.
about what? Remember the driving instructor who was giving the driving lesson? Yes, you know what it is. It doesn't matter that you're a new driver.
Yeah.
Yes? It doesn't matter whether you're a new driver. You are a driver. New
That's-
or old, experienced or not experienced, makes no difference. You will be held to the same standard as every experienced driver.
Yes.
So can James say it's not my fault because I only graduated last month?
No.
No. So you will say, with regard to Rick, James does not have an excuse that he's newly qualified, and the case law is Nettleship and Western. He has a duty of care. Why? His doctor and Rick is the patient paying him to have his teeth fixed. Is there a breach in the duty of care?
Yes.
Yes, because he injected you in the vein,
Nerve.
in the nerve that he shouldn't have, so breach. Is there damage as a result of this breach?
Yes,
Yes,
causation.
because now his face doesn't stand correct anymore. Yes?
Remoteness. No.
Remoteness. Nettleship versus Western. In week 10, you don't ask
We
me
d-
the name of the case.
Yeah,
You ask
we
me
mentioned
the
it
name of the
today.
case
We
in
did
week
it
one
today
and
as
week 2, not in week
yeah.
10. Weston. Nettleship versus Western. Okay, so what is the thin skull rule? Treat the victim as you find it. Yes? So, it is not the victim's fault because the victim has a thin skull, because the victim has brittle bones, because the victim has high blood pressure, whatever it is. That's your victim. If you behave, nothing's going to happen. So you discuss the thin skull rule as well. The case law, Smith versus Leach, what's that about? So why do you nod your head when I say?
Because I have it down, scared,
Because
like
you
on my
have it
back
down.
by.
Yeah.
So you know what the case is, you just don't remember what it's about.
Yeah.
Okay. So,
So many cases.
is it Smith versus Leach or is it Smith versus Leach brain? Very good, very good, very good. Wagon mound, number 1. Yeah. So Smith versus Leach brain. You say and, I don't say and.
Do we mention Caparo in duty of care?
Caparo is business.
Oh, sorry.
First.
Right, what is
Caparo,
wagon mound
no.
number 1?
It's
You know what it is? Then you need to explain it, okay? So now I've given you 3 whole cases.
Okay.
Yeah? Nettleship, wagon mount number 1, and Smith and
Smith, Leach
according
brain.
to her, and Leach brain according to me versus Leach brain to the day I die. So with regard to Rick, everyone's happy, yes?
Yes.
You will write all of these.
This is for
With regard to Carol, the lady who had her teeth done, there was no problem with fixing her teeth, but as she was walking through, she slips on some children's toys, she falls, and she injures her shoulder. Is the doctor liable?
Not the doctor, the hospital.
Well, she didn't do it in a hospital, she went to the doctor's surgery, the dentist surgery.
Yeah. Yes.
What is a res ipsa
Loquitur.
loquitur? It speaks for
The fact
itself.
speaks for itself.
Yes.
this morning.
You learned it this morning?
Yeah, very
Okay.
good.
Gosh, my mom.
Res ipsa loquitur.
If you learned res ipsa loquitur this morning, Carol's case is a classic example of res
Res ipsa.
ipsa loquitur. Had it not been for the fact that the dentist surgery were negligent in not tidying up children's toys from the hallway, she wouldn't have fallen down and broken her neck. The fact is, they are responsible. Why are children's toys there? The doctors, the dentist would say because a lot of our patients are children, and if they wait, they're bored, and then they shout, and then they cry, then they make a lot of noise. So we put toys here to keep them quiet and happy until it's their turn, which is fine. But if you've got toys there, you're responsible to ensure that the toys are used for the proper purpose. Played with by the children and then set aside, not left in the middle of the hallway for people to trip over. So, could the doctor say that actually Carol is responsible for herself
No.
because she wasn't looking where she was going? What does the rest ipsa loquitur tell you? Whatever it tells you, you're right for Carol. Happy everyone?
Yeah.
Great. Nassim.
Contrib-
Now, here we have the case of apparently consecutive torts. Do we?
Contributory negligence, no?
Maybe. What are the... Well, first, let me ask a question first, and then you ask a question.
Oh, no,
Because I was halfway through asking my question. What are the consecutive torts here?
Oh. Economic laws, no?
In this particular case, what happened to Nassim? First of all, he was whacked, punched in the mouth by his brother. So would Nassim have a case against his brother?
Yes.
Why not?
Yes.
Yes.
Would it be assault and battery?
Yes.
Yes.
Which one?
Battery.
Assault and, I would say,
Battery, definitely. Possibly assault.
assault, I would say both.
Battery.
I would say both.
I'm gonna say assault.
Well, if some is saying assault and some is saying battery, then let's not say both.
What's like what you-
There's no apprehension in they hit you from the back. But assault is when there's an apprehension, like I'm scared of you, but then after I'm gonna punch you. That's assault, because you can see I'm gonna punch you, so you have apprehension. Or I'm telling you I'm gonna punch
Oh,
you,
yeah,
and then
yeah, that's it, yeah.
Well, me, I don't teach top law. What I do know is what I have in front of me. It says battery and then in brackets, possibly assault.
Yeah.
So you guys say battery and then explain that maybe it could possibly be assault or not. Yeah? That's how you do it. Don't all do it in the same way, because then they're all going to know that you all cheated off me. And I cheated off a source that I shouldn't be cheating on. Yeah? So there you go. So, but consecutive talks. So one thing that happened was he got hit by his brother, which caused the first problem for his tooth.
Yes.
And then the poor dentist fixed it
Mm-hmm.
and told him for 3 months, behave. But he refused to follow his
causation.
dentist's advice, and he didn't behave, and he went and he played rugby, and somebody tackled him, and he lost a tooth. Does he have a claim against his dentist?
No.
No.
The dentist didn't do anything wrong. Yeah, it was his fault.
But for
whatever
him,
reason.
but for.
So, a case against the brother, yes. Does he have a case against the other rugby player
Yes.
who tackled him?
No.
Yes.
it's foreseeable thing that they
It's
he's gonna get
foreseeable.
No, it's foreseeable. It's sports. So certain damage with that injury is
What's the
foreseeable.
Latin word when it comes to sports?
Voluntary non-fit injury.
Non-fit injuria, yeah, not juria. Injuria.
I tried. Give me my flowers.
Volenti not non-fit
Fit
injuria.
injuria.
He took the risk. If you're going in the boxing ring, you're not going in the boxing ring to eat cake and drink coffee. You're going to the boxing ring to
Yes,
punch the other guy
yes.
and be punched by the other guy, and one of you wins. The loser then can't run to the courts and say, I'm suing because I got a black eye and a broken lip and, you know, a dislocated nose or whatever. Yes? Volenti non-fit injuria. In this case, you're playing rugby. Rugby is a contact sport. And if you're idiot enough and foolish enough to go and play rugby when your doctor tells you don't play rugby or you're going to lose your tooth, then volenti non-fit injuria. Yes?
Yeah.
So should we say there is no claim? That's it?
Well, I haven't finished yet, have
Haven't
I?
finished.
You should have let me finish. You didn't let me finish, so now I'm not going to finish. So,
Please finish.
okay. So, it was a dangerous tackle. Yeah? But a dangerous tackle gets what? You get a free kick or a penalty or you get sent off, something like this. Was it premeditated?
No.
No.
If it wasn't premeditated, then the
Lack
other
of
rugby
intention.
player is not at fault. It wasn't intentional. If the other rugby player intended, instead of I'm playing rugby and in playing
malice.
rugby we have these kinds of tackles, with malice, I want to beat you up, I want you to lose that tooth that is already half lost, then it would have been a different story. But it would be very difficult to prove that in a court of law. Yeah? Yeah, it doesn't say it here, so with regard to the other rugby player, in my most humble opinion, he doesn't have a claim, right? Now, with regard to consecutive torts, there are two cases that are important, and you need to mention them both, at least these two, if not more. One is jobbling
Oh.
this morning, okay? So see how lucky you are to have me this afternoon?
Yes.
Imagine you had me this morning and I'd be talking about these things and you're saying, he's talking nonsense. What is he talking about?
But that's one, what's the other?
The other one is Baker.
Yes.
Yeah, we did both.
Is it
Oh,
both?
we did 3 actually. Baker and another case.
Okay, well, I don't know if the other case,
Fetch out.
I don't know if that one fits this or not.
Fetch
I
out.
don't teach tort. If it fits, it
Yeah.
fits. If it doesn't fit, it doesn't
I
fit.
think those two that Ali mentioned fits better.
Who knows? Erica, you had a question.
How do you know?
Wait.
Wait.
You had your hand up 5 minutes ago.
Because the TV is off.
Of course it's off, because if the TV is on, then you're going to see what I see, and you're all going to take your phones out and tick, 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 and somebody is going to forward it to somebody else.
Yeah.
Then I'm going to be called in before the people that I should be called in,
And you didn't know, sorry.
and then I lose my job.
No,
So,
please, you need to stay here.
yeah. So that's why it's off. Of course it's off.
Can't afford that.
Right. So is everybody happy with question number 1? Yes.
For Carol and the surgery,
Yes.
do you know any case law of apart from Tesco and
Apart from Tesco,
White and Tesco?
Ward and Tesco, you're already ahead of me. I don't even know Ward and Tesco.
Okay,
I don't
do you
teach
know
law.
another case law?
The only thing I know is on this piece of stuff before me, it says Carol, and then it says res ipsa loquitur. So for me, that's it. But for you guys, because you have to give long, explained answers, then explain what this means, explain case law around this, and get a good mark. Yeah? For me, this is all double Dutch. It's no speak of the language for me. I don't know what any of this means. Shall we move to question 2?
No, please. Sorry. The last one.
Which last?
Is there not
Case with the-
yeah, consecutive thoughts?
Yeah?
Is there contributory negligence in that?
Do I look like somebody who knows what contributory is?
Fair enough, fair enough.
Okay. Contributory negligence, ladies and gentlemen, is when you yourself, through your own stupidity, cause part of the injury that you're suffering. Yes? So I'm driving without wearing my seatbelt.
Okay.
Some idiot is driving drunk. That drunk idiot driver hits me.
Oh,
I am
okay.
injured.
Okay.
As a
Yeah.
result of my injury, I want to sue him for everything he owns. But he in court says, my drunkenness wasn't the only cause of your injuries.
You were not.
Had you been,
I got
it
scared.
doesn't matter, that's,
I got scared for you.
I
got
switched
scared for
round.
you.
Don't worry, I switched round. This is the one that you all have on VLE.
Yeah, I got scared for you.
So, the drunk in court would say that I am partially responsible for my own injuries because I wasn't wearing a seatbelt. Had I been wearing it, there would have been less extensive injuries. So the court will say, out of the £100,000 that were
Divided
the
into
total
two.
damages, he will pay me 70 or 60 and the rest comes out of my own pocket. So next time round I learn to behave and wear my seatbelt. Now, your question is, do we have such an issue
There.
here
No.
when it comes to Nassim?
That's it.
I would say, with regard to the rugby player, Nassim is 100% responsible himself. With regard to the doctor is not responsible at all. With regard to Nassim and his brother, still Nassim is not responsible
Okay.
because the brother whacked him in the mouth and the brother should have known better. Yeah? The brother can defend himself. Self-defense means protect yourself from Nassim if you have an argument. It doesn't mean hit him as hard as you can in the mouth.
That was
So
malicious.
there's no contributory here.
Okay.
Yeah? Happy?
Yes.
Yeah.
Question number 2 now. Now that you're all happy with question 1. Question 2 is about Delia, who lives in a village called Bamford. Every year they have a competition for the best garden. Delia decides to enter the competition. 3 things happen. By the way, if John, anytime in this week or next week or week 12, says, let's look at these.
We
We
look
look.
at it.
We look.
No, you haven't yet.
No, we haven't.
You haven't.
They haven't.
But I said, if anytime this week or next week or the week after, he says, let's look at it,
Pretend.
you will not tell him that you've already
We
seen
pretend.
it.
We say
Yes.
nothing.
You will always think, this is the first time. You know, this is really difficult because what I don't want is John to be angry at me. This is none of your business. What have you been doing, telling people things that they shouldn't know? Yeah. So you will deny any knowledge of knowing what's going on, right? Now, Delia and her village. Despite numerous warnings, the children continue to climb into her garden to steal fruit from her trees. On one occasion, one of the children, Rania, falls from an apple tree and breaks her arm. Is Delia responsible?
Yes.
Why?
Because there's something she has that attracts children. It has a name. An allurement. The fruit trees are an allurement.
There's a wall there, a child climbing over a wall into her garden
To take
steal
fruits.
her fruits.
It's an allurement.
Well, they are trespassing, but why should Delia be responsible? If I have a TV set in my home, or I have law books in my home, does that mean you're allowed to break down my door and steal
No,
my law
because
books?
because in trespass, when it comes to children, there's something called an allurement.
English law is crazy. If I have a toy in my home from when I was young, and I've kept it to pass down to, I don't know, my own children or my grandchildren or great-grandchildren, and then a
Yeah,
child
but there's a
breaks into
case.
my home to steal it.
There's a case for this.
Well, okay, I don't know. I honestly
Yeah.
don't know. So we'll get there. So with regard to
No, that's the word,
Rania,
allurement.
who falls down from the
Record.
apple tree and breaks her arm, my understanding might be different from what English law says. Because if English law for you guys says the poor homeowner is responsible, my understanding is the homeowner isn't. Yes?
True.
But we'll get to it when we see what the answers are. I don't know yet until I flip.
Okay.
Number 2, Delia has a neighbor called Tony. He enters into the same competition for the annual best garden that Delia enters into. He is jealous because Delia's garden is better than his. So he lights a bonfire in his own
Malice.
garden for all of the smoke to drift across to Delia's garden so she can't enjoy sitting in her garden and looking at all of the wonderful flowers and trees and everything that she
You're
has.
recording.
Is Tony liable for the tort of nuisance?
Yes.
Good. Number 3, hours before the judges are due to visit the gardens to look at them and then choose which one is the best garden in the village, Delia discovers that the fountain in her pond is not working. She calls a local repairman called Ken. Ken says you have an electrical fault. He repairs the fault, apparently. But when the judges come to look at the garden, the head judge gets electrocuted because he touches a live electrical wire next to the fountain that Ken was supposed to have fixed. The reason that the wire electrocutes the head judge is found to be Ken's faulty repair. Now, who's responsible? It depends. Is a good lawyer answer. That's a great lawyer answer. Because Delia's lawyer would say Ken is responsible, Ken's lawyer would say Delia is responsible, and this judge, Mr. Walter's lawyer, would say, I don't care who's responsible, just give me the money. Yeah? So, now, we have to advise Delia if the parents of that little girl, Rania, can bring a case against her. If a claim can be brought against her by the silly neighbor Tony, which should be the other way around actually, she takes a claim against Tony. And the
No,
third one,
actually, Mr. John said that it's not advice there, advice the parties. He didn't edit
He
it.
changed
Okay.
it, yeah, but we didn't, you're right. But well spotted.
Okay, so if it was me, I would give you one whole extra mark, but it's not me, it's John, so who knows. Okay, question number 2 then, one by one. What I will do now is,
Turn it off.
yeah, turn it off, and
Just
then
be nice and obedient because
switch from one page to another page. Okay, so with regard to Rania, well, first of all, for this question, what you have to do is you have to talk about
Occupiers liability.
Occupiers Liability Act of
1957 and 1984.
Both of them, 1957 and 1984. Very good. And then you have to talk about trespass and nuisance. Happy so far?
Yeah.
Now, good. So now that you start off your answer with Occupiers Liability Act of 57 and 84, what they are and how they're different, and what 84 says that 57 doesn't say, what the law around trespass is, what it means, what is the law, the tort of nuisance, etc., etc.
Why would nuisance is
Why? Because
The children.
second part
the second?
The second part,
is
the
the
fire.
nuisance part.
The
So
fire.
when you're answering the question, you start general discussion before ABC, 1, 2, and 3. In general, you will say, this question, this problem question, deals with issues around Occupiers Liability Act 1957, 1984. It deals with trespass, which is this. It deals with nuisance, which is this. And now in detail, we're going to go through section by section. Then you will say section 1 is the child called Rania, who jumps over the neighbor's fence, Delia, to steal apples. She falls down the tree and breaks her arm. If it was me, I would send the father of this child to prison to teach him a lesson. Next time, you teach your children to behave and manners. But I don't make the law in this country, so don't write that because you're not going to get marks for it. What this thing in front of me says under Rania is trespass, Occupiers Liability Act 1984. What you guys make out of this
It's
is
up
what
to
you
us.
make out of it. So explain trespass. She shouldn't have been trespassing, absolutely, but she's a minor. Is she responsible as a minor for trespass?
No.
No. Could her parents be held responsible because she was not under their authority and not under their control when she unlawfully entered into somebody else's property? Why does this happen? Jay, what happened to my page?
Someone has a remote control, Harry. Someone secretly has a remote control.
Hang on, I'll bring it back. Yep, something serious is going on. Something seriously wrong is going on.
Hackers.
Here we go. Okay, right, so for Rania, you will explain trespass, you will explain Occupiers Liability Act 1984, the second one, yeah, the latest one. But I don't know any more details, sorry. If there's any case law, then do the case law, I'm not sure. With regard to Tony, it's clear, isn't it?
Yeah.
It is the tort of nuisance. So you will explain the tort of nuisance, you'll talk about the case law around it, and you will say that his act is malicious. Why is it malicious? Because
The
he
intention.
is stopping her from enjoying her land, enjoying her property.
Intentional.
Yeah? So explain the case law around this. He did it on purpose, and he should be okay. The third part was this judge who came to judge all of the gardens, and then he got electrocuted in the garden belonging to this poor Delia. Here it says Occupiers Liability Act 1957.
Oh, non-visitor.
You have to talk about visitors, yes? And then it says you have to talk about independent contractors. Who's the independent contractor? Probably Ken, the electrician.
Yeah.
What liability does Ken, the electrician, have? Then you have to talk about, which is the third bit, occupiers' liability for such incidents causing injury and damage to third parties. The occupier is the Lady Delia herself, yes? So, in addition to the independent contractor, apparently, Delia herself will also be liable,
Yeah.
even though it
Duty
wasn't
of care.
her fault. The fault was
Duty of
Ken's
care.
fault because of Ken not properly laying the wires, electric wires, yeah? So,
But she should have checked.
she should have checked. But how can she check when it all happens 2 hours before the inspection? She doesn't have time. the law says I don't care. doesn't it?
Yeah, she was obvious.
That's why the law is bad. Okay, so for the third part, Occupiers Liability Act 1957, you discuss visitors. Then you talk about the liability of an independent contractor who was Ken, who was the electrician. Then you will say, even though Ken is responsible, Delia will also be responsible because she's the occupier, and an injury or harm or damage has happened to a third party, the judge, while he was on her land, her property. Happy, everyone?
Yeah.
Good. Now we turn to number 3. Yes?
You don't have any case law.
If I did, I would tell you. But unfortunately, I don't.
Any suggestions?
Do I look like somebody who knows tort law?
Yes.
Yes.
No, ask me about constitutional law. Ask me about constitutional law. Don't ask me about torts. If I knew tort, I would teach tort.
You did well.
Is this the right one yet?
Yeah.
No, you see what worries me, because not in this class, but I've had another class where I talked to the students and I said, look, these are the rules. Keep your phones down. Yeah, this is risky business. And they all said yes, and then an idiot is hiding and thinks I can't see, you know. I'm an old man and I'm half blind, but I'm not completely blind, you know. Just don't do it. I mean, how is it going to help you? It doesn't help you. What happens is you fail anyway, and then when you resit, you fail the second time round, then you have to chase me for a whole trimester trying to make sure that you get 40% for the third time. It's not worth it.
But they don't even rephrase or anything. They just like straight like that.
Anyway, where are we? Question
Janice.
3. Janice was the manager of a local superstore limited, which is a small supermarket in Chelmsbridge High Street. The following 3 things happened recently. A. She's unhappy with Bob, who was one of the cleaners, because he was slow. She ran towards Bob shouting. Bob was scared. He thought Janice might hit him, despite the fact that everybody knew Janice was a really gentle person. Does Bob have a case
Yes.
for assault and battery against Janice?
Yeah, verbal
Even
assault.
though she's nice and kind?
Yeah, he has a case. He fear,
Why?
the fear, immediate
Is
fear.
Fear. Very good. Klaus, the deputy manager, seeing Janice is unhappy about the cleanliness of the store, says no employee will be allowed to leave until the store is completely clean. When the opening hours end in the evening, Klaus locks the door. And everybody has to clean up before they can leave. After an hour, when everybody had finished cleaning, he unlocked the store. He unlocked the door. But during this period, when all of the employees had spent an hour of their own time cleaning, none of them realized that actually Klaus had locked the door on them. So automatically, when their shift ended at 5 p.m. and they were meant to go home, instead of going home, they started cleaning up until 6. Klaus had locked the door to stop them going anyway, but they hadn't realized it. At 6, he unlocked it. They still didn't see him unlock it, and they just walked out at 6 as if nothing has happened. But Klaus
Yeah.
had locked the door on them.
Committed a tort.
Is that false imprisonment? Or
Yes.
It is. In my opinion, it is. I don't know what this will say, but I'll find out in a minute and I'll tell you. So, we've got the issue with poor Bob, who was scared of Janice shouting at him. We've got this nasty Klaus. And then thirdly, Peter. He is a trainee doing work experience there. He was collecting trolleys from the car park. That's what they do with you when you're a work experience trainee. They get you to do all of the shit work. You don't really learn anything much, but you have to do all of the hard stuff that nobody wants to do. He was not looking where he was going. He pushed the trolley into the side of the new car of a customer called Vikram, causing £4,000 worth of damage. Employer's liability?
Yeah, vicarious liability.
Vicarious liability, easy. Next one. Because of a staff shortage, Janice tells her 15-year-old daughter Daisy to help unload the delivery lorries. Daisy damages her back when she's carrying a large box of celery into the store. Is Janice responsible for her mother's... is Janice the mother responsible for Daisy the daughter's damaged back?
It's mixed. It's both.
Because she's not an employee.
She's not an employee, but she was doing it in the course of, in favor of the company.
But she's not being paid. She's
Yeah.
not being paid.
No, but there's a case like that where you're doing it on behalf of the company. Yeah, it's both ways. So
Both ways?
yeah,
Okay, so you guys
like
don't
a triangle.
know behind it.
It's a triangle. Remember the triangle he drew? Yeah.
The other case actually is not viable because in the other one, the court
Yes.
said that
Barclays.
it's
Yeah,
not viable.
Barclays.
Not Barclays case, it's another one.
Which
Why
one?
does this keep
So there is Rose case
I'm
and then
scared. Something's
Remember when we did the pop tutorial? Anyway, he'll tell us now.
the Rose and Plenty case. Yes, that one is a file.
There's a torch triangle when you're doing it in favor of the company.
The court put upon someone and he wasn't supposed to take it.
No. But he wasn't doing it in favor of the company. He was doing it for himself.
Yes.
As well.
The other case, they were doing it in favor of the company. So the company was like,
Rose is a file on
Was put it.
yeah.
Is it was an offense? No.
We should say,
I
I
know
know
what case
and
you're talking
say
about.
that the other one is not viable.
But
He
yeah.
wants you to mention.
Do you guys want to go home?
No.
I
Sorry.
do. So,
Sorry.
Oh, yes,
I do.
in that
So
case.
the sooner we get this done,
Okay,
then
Sorry.
you can stay here until midnight and I will go home.
Sorry.
And discuss everything until midnight, but I want to go. So with regard, well, before we talk about Bob and Klaus and Peter and Daisy, again in general, you need to cite and apply the main legal principles that apply to assault, false imprisonment, vicarious liability, breach of employer's duty, and all of the case law for each of these four. So, assault with its case law, false imprisonment
Yeah.
with its case law, vicarious liability with its case law, breach of employer's duty with its case law, yes? So, now that you know what you've got to do, the first case, Bob, he was scared of Janice running towards him, shouting at him. Is this assault?
Yes.
If it is, you would explain why with the case law.
What case is that?
Do I look like I know anything about law? Tort law.
Okay, so Bob, assault plus the case law. Klaus, false imprisonment against the employees, yes?
Yes.
I think yes, but you need to add the case law, whatever it is. Peter, causing damage to the customer's car, the customer called Vikram. Is this personal liability of Peter, or is
No.
it vicarious liability?
Vicarious.
But Peter wasn't an employee, remember? Was he an employee?
Yes.
He wasn't.
He was a
said
trainee.
earlier, he is there doing training.
Oh, training.
Yeah, but they employed him for the training.
Yeah.
No, but you might be doing trainee as a volunteer.
Well, he didn't say volunteer, so
He still work.
Then your answer would have to identify
If it's
whether he's
personal
being paid
or
or not.
vicarious.
Does he have, for work experience,
Yeah.
does he have a contractual relationship which would be a worker or not?
The relationship akin to employment applies.
Because he's
Sorry?
work
A relation akin to employment.
Akin to employment, so akin to employment, that was section 230E of the Employment Act or something like that? Did John talk about this, or is this too
No,
He
he-
did mention something about it. Yeah.
akin?
We did it based on common law, not on statute.
Okay, because for employment law, there's a statute about it, but because I don't know employment law, I don't know the statute. Did he talk about E's case, the priest, who was abusing children in the church?
yeah,
Tell us.
yes. But Ali, tell us.
I don't know whether it fits here or not, but there is a case where every church has a priest, yes? And in every area, all of the priests in all of the churches fall under the responsibility of the local bishop. Yeah? So one of these churches, the preacher was sick, ill. He was off. So they had trouble. They needed to find somebody to come in on Sunday to do the sermon. And during the week, they have classes for the children, Bible class, etc., etc. So they bring in somebody, a temporary priest, to help with the Bible classes and all that. Now this temporary priest was a pedophile, and he sexually exploited the children. Now, in my law, you hang him. Yeah? For me, death penalty, eye for an eye, tooth for a tooth. None of this go to prison for 3 years and be released after a year and a half nonsense. Okay? But I don't make the law, unfortunately. Now, the parents of the children who were angry were saying, okay, a criminal case against the priest is part of the issue. But then there's also the money that we need to make out of it, the damages that need to come. Why? Because we have to spend a lot of money for a psychiatrist, psychologist, whatever, to counsel the children who've been abused. And who's responsible? They said the churches. And who represents the church in that area? The bishop. Yeah? And they were saying, we're not responsible because this priest was a temporary priest. He's not an employee of the church. He only came in to cover a shift, like Ali's come in to cover a shift today. And therefore, go and get whatever money you can from the priest. And the priest, of course, has no money. And the court had to decide whether the church, which has deep pockets, and the Church of England has a lot of land and a lot of property. The Catholic Church is even more rich than the Church of England is. Whether the church is responsible or not. And the judges, in this particular case, they made the right choice. Normally they don't make the, well, not normally. Sometimes they don't make the right choices. This time they did. They said that there is vicarious liability. They said that the relationship of this temporary priest was not an employment relationship because he wasn't properly attached to the church, but it was akin to employment, something similar to employment. So you don't have to be an actual employee. If your relationship with the company is not actually employee, but something similar to employee, then the company is still responsible for what you do. So this is that particular case. What we have here, however, for Peter, for this young guy who is there doing work experience and damaging somebody else's car, it says personal / vicarious liability. So probably it means in your answer you're going to have to explain both. It would be personal liability of this young boy if under the law his relationship was not an employment relationship or akin to employment relationship, because then the company would have no responsibility towards the smashed car for what he did. But if the court holds that his relationship was akin to employment, then it would be vicarious. So your answer, in order to make sure you get maximum marks, should cover both. Yeah? That's what I think. There's no examples of case law here, so I don't know which cases to tell you to look at. Yes?
That was my question about the case of the name of the child.
I don't know. I really don't know. Yeah? Finally, the fourth and last one, Daisy. What was Daisy about? The daughter of the daughter of the owner. Yes.
When you say you took over both these, vicarious liability, what else?
No, my career is in personal.
Personal liability
Yeah.
is I have personal liability if I slap you, but also vicarious liability because at the time I slapped you, I was employed by Anglia Ruskin. So if you want to sue me and I've got nothing, you'd sue Anglia Ruskin because they've got lots and lots of money. Yes? So that's kind of, yeah. So explain both. Would the boy be personally liable if his relationship wasn't an employment relationship? If it was, then would the company be liable instead of the boy? Because the boy is a young boy, 16 years old, and is doing work experience, and he doesn't have a penny to his name. Yeah? So 4,000 damage of your car, you can't get it back from him, but you can get it from the company because they've got deep pockets and they're insured. Right, Daisy was the 15-year-old daughter of the shop owner, the owner of the company, Janet. She helped her mum with deliveries because they were short of staff. While carrying the large box, she damages her back. Is the business responsible for the damage to her back? Can she put in a claim against the business, against the company?
Yes.
And you've been doing business law with Ismini, so you know the company is separate from the shareholders, etc., etc. So her mother won't pay, the company will pay, yes? Can she do it?
Yes.
Yes.
Well, I don't know, yes or no, because I don't know torts. But what this is saying, in the kind of the answer guide, is Daisy an employee, question mark, and then employer's duty, question mark.
Yes.
So your answer should be around the guidelines of explaining if she's an employee or not. So start with that. She isn't an employee, she happens to be the daughter of the owner of the business. Nothing in the scenario tells us that she's an employee. She exchanges labor for money. Therefore, apparently if she's doing it out of favor for her mother. And if she's doing it as a favor for her mother, not doing it for the company, should the company be liable? Probably not, yes? However, does the employer have a duty of care towards everybody who's on the premises and who is working? An employer would have duty of care towards somebody who's on the premises and is not working, me the customer. I slip and I fall down and break my back, the employer is still responsible. So, shouldn't they have a duty of care towards somebody who's actually helping them out? Then they should. Yeah? So you start off with her relationship as a private family relationship, mother and daughter, nothing to do with the business. She responded to her mother's call to help, not the business's call to help. So one argument would be that she's helping her mum, not the business company. Is not responsible.
However.
And then, yes, the second paragraph would be the however paragraph. Yeah. What are the duties of employees? And you'd explain all of those, and you would say, well, there's a possibility, therefore, that she is. It depends on which judge you get. Yeah?
Lord
Basically,
Denning.
don't open my mouth about anything after 4 p.m. Because not nice things will come out. Right, happy everyone?
Yes.
Okay. So I was not able to help you with regard to sustainability.
You did help.
Maybe I've been a little bit helpful with.
You did help with sustainability. Psychometric.
Thank you.
Avuna.